All right, this is the docket number 25, document number 25 in the Schuyler Barbeau case. This is his address. We pray you guys write him a letter. We're going to work our way through all of these legal motions that Schuyler suggested we read. And so let's get on to it. This is the defendant's motion to dismiss regarding the Second Amendment and Commerce Clause. It's dated March the 4th of 2016. Evidentiary hearing requested. United States of America versus Schuyler Pyatte Barbeau. All right, here we go. The defendant, Schuyler Barbeau, through counsel, Assistant Federal Public Defender Dennis Carroll, submits this motion to dismiss the indictment because the offenses with which he is charged violate the Second Amendment and the Due Process Clause to the United States Constitution. Mr. Barbeau requests an evidentiary hearing. In support of this motion, Mr. Barbeau submits his declaration attached as Exhibit 1, and he also requests an evidentiary hearing. 1. Procedural history. On December the 16th, 2015, Mr. Barbeau was indicted on one count of possession of an unregistered firearm, short-barreled rifle, in violation of 26 U.S.C. 5861D, 5845A3. The government has informed defense counsel that it plans to seek a superseding indictment charging Mr. Barbeau with an additional offense, possession of a machine gun, in violation of 18 U.S.C. 9220. Both counts will be addressed herein. Trial is currently scheduled for May the 2nd, it says 2106. That's like over 100 years away, or 90 years. I think they made a mistake. In any event, factual background. According to the complaint, docket number 1, federal agents received information from a confidential source that Mr. Barbeau possessed a short-barreled rifle. Mr. Barbeau gave the rifle to the confidential source so the source could sell it. Agents obtained the rifle from the confidential source and verified that it is an unregistered, fully automatic, short-barreled rifle. There is no dispute that Mr. Barbeau knowingly possessed this rifle. Mr. Barbeau is not a felon. In fact, he has no prior criminal convictions. He is not a drug user, nor has he been adjudicated mentally ill. Indeed, he served 4 years in the United States Marine Corps, after which he was honorably discharged. He then served 4 years in the National Guard. Mr. Barbeau requests an evidentiary hearing to establish the above-cited facts related to his personal history. He also wishes to present evidence that possession of a fully automatic short-barreled rifle is necessary to preserve his right to self-defense due to a variety of facts, including the ubiquitous nature of more dangerous weapons possessed by criminals, gangs, terrorists, mentally ill people, and others who threaten the safety of law-abiding citizens. In support of his request for an evidentiary hearing and dismissal, he submits the attached declaration, Exhibit 1, Declaration of Schuyler Barbeau. 3. Argument. Mr. Barbeau has a Second Amendment right to possess an unregistered short-barreled rifle. In United States v. Miller, 307 U.S. 174, 1939, the Supreme Court held that the federal government could require registration and taxation of short-barreled shotguns without violating the Second Amendment. However, in the District of Columbia v. Heller, 554 U.S. 570, 2008, the Supreme Court held that the Second Amendment protects the right of individuals to possess firearms against certain kinds of restrictions by the federal government. The court recognized that the Second Amendment is not unlimited and does not include the right to keep and carry any weapon whatsoever in any manner whatsoever for whatever purpose. Since Heller, there has been no Ninth Circuit published opinion addressing the constitutionality of the statutory ban of unregistered short-barreled rifles. In light of the reasoning in Heller, this court should find that it is unconstitutional to criminalize the possession of an unregistered short-barreled rifle. The Second Amendment to the United States Constitution provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. United States Constitution Amendment 2. In Heller, the Supreme Court reaffirmed the basic right of all citizens under the Second Amendment to possess firearms to effectuate the inherent right of self-defense. 554 U.S. at 628. As the Supreme Court explained, the Second Amendment safeguards the inherent right to self-defense by protecting from undue government interference the right of citizens to protect themselves, their abodes, and their property, to use arms in the defense of hearth and home. While acknowledging that rights secured by the Second Amendment are not unlimited, the Heller Court stressed that the government restrictions on the right to possess firearms are especially suspect when applied to the home, where the needs of defense of self, family, and property is most acute. The court in Heller found that an outright handgun ban violated the Second Amendment when the specific characteristics of the type of gun itself is commonality and ability to move around the home. The court stated, "It is enough to note, as we have observed, that the American people have considered the handgun to be the quintessential self-defense weapon. There are many reasons that a citizen may prefer a handgun for home defense. It is easier to store in a location that is readily accessible in an emergency. It cannot easily be redirected or wrestled away by an attacker. It is easier to use for those without upper body strength to lift and aim a long gun. It can be pointed at a burglar with one hand while the other hand dials the police. Whatever the reason, handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition of their use is invalid." Thus, along Heller involved a complete prohibition and not registration, as is the case with Section 5861D, which criminalizes possession of certain firearms unless they are registered with the National Firearms Registry. The Heller court nevertheless made it emphatically clear that the government must provide more than a net rational basis to justify any restrictions on a citizen's right to own and possess a firearm. Because the Supreme Court has recognized in the Second Amendment a fundamental right to bear arms, a restriction on that right must withstand strict scrutiny. In applying the strict scrutiny test, this court must review with care each gun law to determine whether it is narrowly tailored to achieve a compelling governmental interest. The Supreme Court has recognized that public safety and the government general interest in preventing crime are compelling interest, and has in a wide variety of constitutional contexts found such public safety concerns sufficiently forceful to justify restrictions on individual liberties. Thus, the question is whether the regulation is narrowly tailored to that interest. In this case, the criminalization of an unregistered short-barrel rifle is not narrowly tailored. There is no specific relationship between public safety and the prohibition against possessing unregistered short-barrel rifles, especially as compared to other firearms that do not require registration. Essentially, there is no functional difference between a handgun and a short-barreled rifle. With a shotgun, the shorter barrel becomes a wider spread of shot, but there is no such effect with a short-barreled rifle. In fact, a short-barreled rifle is more dangerous than a handgun, and is clearly far less dangerous than many powerful handguns that do not require registration. Let me read that again. In fact, a short-barreled rifle is no more dangerous than a handgun, and is clearly far less dangerous than many powerful handguns that do not require registration. While a short-barreled rifle might make a rifle more concealable, that should be of no significance, since all handguns are concealable, and this by itself does not justify government prohibition regulation of handguns. The Heller opinion indicates that any gun laws that burden the right of self-defense by threatening or imposing serious criminal sanctions on firearms possession and protection of self, property, and home are constitutionally suspect and cannot be justified by broad and generic claims about public safety interest. In the instant case, generic claims about public safety interests clearly do not justify slinging out short-barreled rifles for heightened regulation and criminalization. Do not justify singling out short-barreled rifles for heightened regulation and criminalization. Mr. Barbeau has a Second Amendment right to possess a homemade machine gun. Mr. Barbeau recognizes that in United States v. Henry, post-Heller, the Ninth Circuit held that the Second Amendment right to bear arms does not extend to defendant's possession of a homemade machine gun, and that the Commerce Clause authorized a criminal ban on the possession of machine guns. For the record, Mr. Barbeau asserts that Henry is wrongly decided and that a machine gun ban violates the Second Amendment. While the Heller decision recognized that the right to keep and bear arms is subject to certain limitations, the court described the individual right conferred by the Second Amendment as the right of law-abiding, responsible citizens to use in defense of hearth and home. As noted above, Mr. Barbeau wishes to present a factual basis consistent with his attached declaration to establish that possession of a fully automatic weapon is necessary for him to defend himself. The laws prohibiting machine guns are closer to the outright ban of a class of firearms reviewed in Heller. Federal law prohibits the possession of machine guns by ordinary law-abiding citizens, except for those that are registered and manufactured prior to 1986. To the extent that Heller suggests that less common weapons such as fully automatic rifles may be banned, the holding should be reconsidered. That holding should be reconsidered. Dated this 23rd day of February 2016, respectfully submitted Dennis Carroll, Assistant Federal Public Defender Attorney for Schuyler Barbeau. All right. The other thing that was a part of document number 25 is the declaration that was written by Schuyler Barbeau. I'm going to scroll through it, and you can pause if you want to. But keep in mind that I've already read this when I read document number 24. So I'm not going to read it again for a second time, but it's the same document. Okay? Let me just page down, pause. All right. It's exactly the same document that I read in document number 24. All right. That's document number 25. We'll continue to work through these, and we'll get all the documents that Schuyler thought was important read into YouTube. I've also got a DropBox location where you can download all of these documents and read them on your own if you don't like to hear my voice. We certainly encourage you to become acquainted with the arguments put forth in the Schuyler Barbeau case. And not only that, we encourage you to write a letter to Schuyler Barbeau. Let him know that you care about him and that you appreciate what he's doing in standing up for the Constitution and the Second Amendment.